The Rajya Sabha is merely a secondary house rather than a second house in the Indian parliamentary system. Critically analyze the statement. Also, compare and contrast the position of the Rajya Sabha vis-a-vis the state legislative council's approach. State the reasons why the Rajya Sabha has been deemed as a secondary house in the Indian parliamentary system. List the importance of the Rajya Sabha. Compare and contrast the position of the Rajya Sabha and the state legislative councils. Answer. The Indian Constitution provides for a bicameral legislature comprising of the Rajya Sabha representing Indian states within directly elected members and the Lok Sabha representing Indian people with directly elected members. The Arts has been deemed as a secondary house because it is considered to be a delaying house, which prolongs the bill passing procedure. It has an unequal status vis-a-vis regarding introduction of money and financial bills, and it cannot pass a no-confidence motion. It is criticized for being a haven for crony capitalists, party fundraisers, etc. who are more interested in their party agenda than their representative states. Further, domicile requirement has been removed post-verdict in Kuldip Nayar case 2006. Par's elections are notorious for alleged poaching by political parties. In joint sittings, the will of LS supersedes the apprehensions of ours due to the former S numerical strength. However, there are a number of areas in which it enjoys equal powers to that of LS-AMD, some in which it enjoys greater powers than LS, making it an important parliamentary institution. It maintains the federal equilibrium as it protects the interests of the states. Bills passed hastily in Lok Sabha are intensely scrutinized in the Rs. It provides for representation of eminent society members via nomination who otherwise may not participate in elections. It has equal powers with the LS regarding ordinary bills, constitutional amendment bills, and approval of ordinances. It has two exclusive powers: to authorize the Parliament to make law on a state list subject Article 249 and to authorize the Parliament to create new All India Services Article 312. Position of the Arts vis-a-vis state legislative councils. SLCs, Rs and SLCs are upper houses in the Parliament and state legislatures respectively. However, Rs is a permanent entity while SLCs optional entities that can be abolished. The Arts consists of state representatives and maintains federal equilibrium. The issue of federal significance does not arise in the case of the SLCs. SLCs act as dilatory chambers as they can only delay an ordinary bill for maximum 4 months. The Arts has equal power with the LS regarding ordinary bills. Both Rs and SLC can delay money bill by 14 days. The Arts enjoys special power under Articles 299 and 312 that is not available to the SLCs. 8. A major shift is needed in the institutional framework of the Central Water Commission (CWC) and the Central Groundwater Board (CGWB) to make water management more holistic and multidisciplinary. Discuss in the context of Mir Shah Committee recommendations. 10. Approach. Discuss the issues with present institutional framework. Mention Mir Shah Committee's recommendations. Discuss how it will create a shift in institutional framework and overcome limitations of these bodies and make water management more holistic and multidisciplinary. Their party agenda than their representative states. Answer. At present, water is being managed under 2 separate heads: surface water and groundwater. However, 2 disciplines are not separate but interconnected. Surface water faces challenges like pollution and unsustainable usage. Also, groundwater levels are falling rapidly and its quality is deteriorating due to poor aquifer management. Therefore, a major shift is needed in the institutional framework to make water management more holistic and multidisciplinary so that water is productively used for irrigation and other purposes. Mir Shah Committee recommended that CWC and CGWB should be restructured and unified to form a new National Water Commission (NWC), since a unified body will help in collective management of ground and surface water. NWC will be responsible for water policy, data, and governance in country. It should be an adjunct office of Ministry of Water Resources and function with full autonomy. Key functions of proposed NWC: I incentivize state governments to implement irrigation projects in reform mode. I lead national aquifer mapping and groundwater management program. I develop a location-specific program for rejuvenation of rivers. 8 divisions of NWC proposed: irrigation reform, river rejuvenation, aquifer mapping and participatory groundwater management, water security, urban and industrial water, water quality, water data management and transparency and knowledge management and capacity building. These 8 divisions would create the necessary institutional framework required for efficient water management. It will help devise cost-effective and appropriate technology to recycle and reuse urban and industrial wastewater. It will create and maintain a transparent and accessible system of data management on water for public use. The framework would lead to participatory water management. Advantages of the new institutional framework: holistic and multidisciplinary. Synergy between surface and groundwater efforts. Better coordination of agencies. Shifts focus from construction to management and maintenance. A high-level central organization that is forward-looking, strategic, agile and transdisciplinary in its skill set will overcome maladministration by CWC and CGWB. Focuses on new challenges like water quality, industrial pollution, data management, etc. Basin-level management and location-specific strategy involving states will minimize conflicts between states and promote cooperative federalism. However, the new framework faces certain challenges such as centralized body, susceptible to bureaucratic inefficiencies of large organizations, participation of states not obligatory. If the current pattern of water usage continues, about half of the demand for water will be unmet by 2030. Thus, the recommendations for institutional overhaul are welcome given the unprecedented challenges of water management in the 21st century. 9. On what grounds can a person be denied the right to contest election to the parliament in India? Will a lifetime ban on those convicted of heinous crimes address the problem of criminalization of politics? Discuss. Approach. List out various disqualifications for contesting elections in Constitution and the Representation of People Act, 1951 RPA. Discuss the recent issue on lifetime ban. Discuss the pros and cons of a lifetime ban. Answer. Article 102 and 191 of the Indian Constitution provide criteria for contesting elections and allow Parliament to frame additional grounds for the same. The Representation of People Act, 1951, Sections 8, 8A and other provisions provide disqualification on the grounds of conviction of specified offenses, involvement in corrupt practices, contravention of certain laws, etc. The maximum term of disqualification is 6 years in addition to the term of imprisonment. Specifically, grounds for disqualification to contest election include Constitutional Art 102, 191 holding office of profit, persons of unsound mind declared by a competent court undischarged insolvent, non-citizens of India, disqualifications under any law made by Parliament statutory section 8, 8A, 9, 9A, 10, 10A of RPA 1951. Certain offenses mentioned in IPC 1860 such as promoting enmity between different social groups, rigor, rape, cruelty towards a woman by husband/relative, preaching and practicing untouchability, protection of Civil Rights Act, 1955 offenses under other acts such as Narcotics Act, terror, Unlawful Activities Prevention Act, Terrorists and Disruptive Activities Prevention Act, etc. According to the Association for Democratic Reform's ADR, 34% of MPS in the 16th Lok Sabha face criminal charges. The percentage in 2009 and 2004 stood at 30 and 24 respectively. Thus, criminalization of politics is a major concern. With rampant corrupt practices and lowering of moral standards of politicians, the Election Commission also supports a lifetime ban on legislators convicted for heinous crimes. A lifetime ban can be a solution as it would deter politicians from engaging in criminal activities. People with clean record only would participate in elections. However, a lifetime ban may not be successful due to lack of political will and the center's opposition to it. Modern democracies are built on principles of maximum participation of citizens, and even convicts cannot be denied such basic rights. Indian judicial system is plagued by delay and corrupt practices. Hence such men may operate as undue harshness on innocent people. Hence, it is citizens' duty to be vigilant and elect people with high moral standards and clean records to address problem of criminalization of politics. Similarly, political parties should field clean candidates in elections to address problem of criminalization of politics. 10. Directive principles can be considered as even more important than the fundamental rights because they provide a positive thrust towards welfare. Discuss. Approach. In introduction, briefly write about the significance of directive principles and fundamental rights in Indian Constitution. List the arguments and evidences supporting the importance of directive principles. Also, enumerate the points to highlight a role of fundamental rights in democracy. In conclusion, emphasize on balance between both the directive principles and fundamental rights. Answer. In the words of Granville Austin, directive principles DPS and fundamental rights FRS are the science of the Indian Constitution. While FRS ensure minimum basic rights to ensure a dignified life to citizens, DPS are considered fundamental in the governance of the country as it seeks to establish economic and social democracy. In the Kesavananda Naradi case, 1973, the Supreme Court highlighted the importance of directive principles as they contain the basic philosophy of the Constitution, which needs to be reflected in the government policies and laws made by the Parliament. Unlike fundamental rights, these principles do not put any limitations on the powers of the state. It covers almost every section of society. For example, children, women, old age, disabled, scheduled caste and scheduled tribes, and therefore helps in the establishment of a welfare state. It also provides a list of areas of governance to be considered. For example, free legal aid, workers' participation, and equal pay for equal work, environment protection, and uniform civil code. However, a role of the fundamental rights is also crucial as they are essential for holistic development of individuals. Protect the liberties and freedoms of the people from being encroached upon by the state or other individuals. Act as limitations on the executive and the legislature. Prevent the government from becoming autocratic or despotic. Help in the establishment of the rule of law. However, the Supreme Court in the Nerva Mills case, 1980, held that absolute primacy to one over other disturbs the harmony of the Indian Constitution. Hence, a balance between the two is necessary to achieve the objectives of justice, liberty, equality, and fraternity as enshrined in the preamble. 11. In light of demands for replacement of the FPDP first past the post system with other alternatives, compare the merits and enumerate the challenges associated with replacing the current system. Approach. In introduction, discuss the reasons for the demands of replacing the FPDP system. Then discuss the merits of FPDP and PR system. Write down the reasons FPDP was adopted in India along with the challenges to replace it. Conclude your answer. Ideally, the middle ground, i.e. hybrid format or status quo, i.e. FPDP system should be supported. Answer. FPDP is simply the system where a candidate who secures maximum votes in a constituency is declared victorious. Recently, the Parliamentary Standing Committee on Personnel, Public Grievances, Law and Justice sought response from various stakeholders on the electoral system. Demands for changing the FPDP system are also voiced in view of the fact that in 2014 national elections a party securing the third largest vote share could not win any seats. FPDP system was adopted due to simplicity and stability. FPDP system presents the advantage of producing a majority government at a general election by being decisive, simple and familiar to the electorate. Participation and representativeness. FPDP system encourages political parties to have more broad-based participation. Accountability. It allows voters to choose between people rather than just between parties. Voters can assess the performance of individual candidates rather than just having to accept a list of candidates presented by a party. Criticisms of FPDP system. It allows a disproportionate relation between the votes a party gets and the seats it garners. For example, the ruling party at center enjoys absolute majority despite getting 1/3 votes. In most cases, the winning candidates do not represent real majority in the constituency. As a result, the legislature is not real representative. It gives rise to electoral malpractices, like communal politics, criminalization of politics, invoking caste and religion in election. Parliament and assemblies are not representative of social groups. In certain cases, Marginalized social groups may not be able to find representation because of their insufficient numbers. In view of these shortcomings, the discussion is going on to reform the electoral process of voting, and proportional representation (PR) or a hybrid system are suggested as the alternatives. Merits of PR systems: it more correctly matches the votes cast and seats won. Encourages or requires the formation of political parties. It gives due representation to all sections of the society, thereby better suited for pluralistic one. Many in the Indian context argue that it would increase women's representation in the parliament. It encourages the parties to go beyond the constituency, thereby restricts the growth of regional fiefdoms. Merits of hybrid system: the hybrid system in the Indian context has been recommended in Law Commission S 170 and 255th reports. In this system, some seats are elected based on FPDP system and the remaining on the basis of the votes secured by the parties in that election. Other countries have successfully adopted mixed system in various forms, such as Japan and South Korea have adopted parallel voting, while Germany and New Zealand have adopted mixed member proportional representation. Hybrid system tries to create a balance between stability of the government and representation of all social groups. However, our constitutional makers adopted FPDP over other systems due to following reasons: difficulty for the voters to understand the system, which is complicated due to low literacy scale in the country; unsuitability to the parliamentary government due to the tendency of the system to multiple political parties, leading to instability in government. It is difficult to organize the bipolls in case of PR system. Problems of logistics and financial resources in organizing elections based on PR on such large scale, in terms of population and geography. It increases the significance of party system and decreases that of voter. With the flaws in FPDP increasingly coming to the fore, the time to look at alternative model has come. Now that the parliamentary committee is set in motion this serious debate, one hopes that the electoral system itself would be taken up as a key reform. As a solution, a hybrid system along with the line of other successful democracies can be adopted.